Supreme Court is angry at the center for refusing to show it the material and the files that form the basis of the release of the 11 rape convicts in the Bilkis Bano case. I'm Barkha Dutt, you're with the Mojo story. The Supreme Court has heard petitions, including from Bilkis Bano herself, asking why 11 men who were convicted of rape and murder. Remember, Bilkis Bano was pregnant, and the men who did this to her, gang raped her, also killed her 3-year-old daughter. She's asking the Supreme Court why there was remission in this case, why these men were released ahead of time, walking out of jail to garlands and to sweets. It has been a high voltage, high profile case. We've been covering it right from the start. Now those petitions have been heard by the Supreme Court, and the Supreme Court is not amused because both the Gujarat government and the center have claimed privilege in placing before the Supreme Court the files, the documents that form the basis of its reasoning for releasing these 11 convicts. Do remember that the Gujarat government took an executive decision right before the Gujarat elections to release these men. One of the Gujarat legislators telling the Mojo story that these men were quote unquote sanskari Brahmins in comments that have gone viral globally. The final decision in the matter will be taken on the 2nd of May. But how do we understand this tension between the center and the Supreme Court? Let's introduce our guests on the program today. Joining us first up is Rishi Malhotra. Rishi has been, of course, a lawyer for the convicts. Can we please bring him in the box and welcome him to the program? Also joining us is Zakia Soman. Zakia, of course, is a well-known rights activist and was at the forefront of the triple talaq fight. She's been speaking up relentlessly for reform within the personal laws that govern much of the Muslim community. It's a great pleasure to see both of you. Let me start up front with you, Rishi. I do remember that time when you told us, first of all, that the center had given its consent to the state. I remember you saying absolutely, absolutely that consent was given. Now the Supreme Court wanted to know the basis on which this consent was given. And we have seen both the state and the center refusing to show this material. Why is that, Rishi?
No, frankly speaking, as an officer of the court in Supreme Court, I was a bit amazed by the yesterday's development because when the court did ask the Additional Solicitor General that whether have you produced the file which were directed in the last order, this was a surprise for me also because he said that perhaps we may move for a privilege thing and we may move for a review of that order where the files were ordered to be brought in. So, of course, they have that privilege. The government can certainly move the Supreme Court because it's all confidential file according to their understanding. So, yeah, bit I was also amazed. But nevertheless, I being the counsel for the convict, we have our certain objections to in fact, the maintainability of the petition of Bilkis Bano herself also.
So hang on, let me understand what you're trying to say. You're actually saying that you do not agree with the position taken by the center and the state. When you say you're amazed, what were you amazed by?
I am, and I was amazed for the reason that when the files were actually in the court, by not forwarding to the concerned judge, this created unnecessary, what you say, not a good taste in judge's mouth also because there's nothing to hide because the state government has already filed in its detailed counter affidavit in this Suhasini Ali's petition. So I believe that everything was already on record. But despite this, the judges wanted to see the original file. So I really don't understand what was so much of concern not to hand over the original file and show it to judge. So this was the thing which I got amazed. But as I said, so despite this nitty-gritties between the state government or the union government and between the bench, there's something which the judge has to consider in the next state of hearing, and which I did mention yesterday in the court also.
Okay, I'll come to that in a moment. But Zakia, you have been among those who have been continuously raising your voice, not just in the manner in which these convicts were released, but what happened to them thereafter, the garlanding, the sweets. More recently, we saw them actually sharing a stage with local BJP leaders in Gujarat, not all of them, but one of them there. You can see those images. Zakia, now you have the center and the state refusing to explain to the Supreme Court what the basis was. Why did they feel the need to offer this remission? Zakia, how do you respond?
So opacity has been a marked feature of this entire episode. Right from the beginning, the way it was handled, things were quite opaque. And now both the state government and the central government are taking shelter under the argument of privilege. So why the need for the invoking the privilege? What is it that you don't want the public to know? What is there something which you don't want to share? There's something to be hidden from the public and from the court. So that is the question. And the court very rightly said that this is not just another case. This is a case, it's a crime against humanity which was carried out in this case. And the victim herself has been running from pillar to post. She has been forced to live in hiding. Her family has been threatened. She has been forced to not come out and reveal herself where she is. So she is undergoing all the hardships. And why is so much consideration being showed for the culprits? And now there is a report that several of them were out on parole for almost like 1,000 days per head, and one particular person was out on parole for 1,500 days out of the few years that they served. So what is the urgency? What is the logic? What is the rationale? We are talking about Nari Shakti, and on the other hand, here is this Nari, this woman, daughter of India, who is trying to fight for justice very courageously. Rather than supporting her fight, rather than recognizing her struggle, we are giving a free hand to the culprits, and we are even claiming the government is even claiming privilege. I don't understand, how. And just because one point I want to make, Barka, just because people are sitting in the government, it does not give them a license to behave as they please. Those who are sitting in the government are accountable. They're accountable to the rule of law. They're accountable to the constitutional principles. They're accountable to legal norms. They're accountable to morality and ethics also. There is
I
some,
agree.
there are some norms of governance. There are some norms of human decency. So out and out, there has been this kind of behavior, which is really quite difficult to understand.
I want Rishi Malhotra to respond to this. The Supreme Court actually went through all the documents and pointed out, and this has been in some of our own investigative reporting, that each of the convicts, even before the remission, Rishi, was granted an average of 1,000 days of parole. One, as Zakia just mentioned, was granted 1,500 days. The court was not amused or impressed by this data. They also did not accept the sort of analogy between murder. They called what happened in Bilkis's case a massacre. They said it would be like likening apples to oranges. As a counsel to convicts, how do you respond to the court's observations on the parole? I'll come to the remission itself later, but on the parole.
You see, this brings me a very important aspect, which rather we have to tell to the court on the next state of hearing, which is that 92 policy. Of course, now Supreme Court has settled this law that it would be the 92 policy of state of Gujarat. Now, what does this 92 policy say? This is very crucial, Barkha. That policy says that it's 14 years with set off. So even if you were to exclude parole period, may it be 1,000 days, may it be 1,500 days, the policy stipulates that it should be 14 years with remission, with parole. It's not actual 14 years, number one. Number two is that what I mentioned before the Supreme Court yesterday was like I have been handling number of remission cases from across country and especially state of UP. Now, if each and every case a person is got remission and a complainant or a victim comes to Supreme Court, it will actually open a Pandora box. Now, certainly this is not the intention of Supreme Court to look each and every file of each and every convict. May it be Bilkis Bano case, may it be an XYZ case. So therefore, this would be what you call Supreme Court would be itself coming into a trap where every victim will jump in every remission case and ask for the government to produce the files and what reasons has transpired. And don't forget, these are sovereign powers of the government, which is done by the governor under 432 and 433. So Supreme Court is not to do and not to look at the decision-making reason in a remission order. Actually, this is not the idea of law. Of course, what they want to see is that whether there was any application of mind while granting remission, and of course that is between the government and the Supreme Court to tell.
So you're saying that this should not be relevant to the final decision. In other words, Rishi, that's the
Absolutely.
point you're making.
Yeah,
Yeah.
because what is relevant is whether there was consideration of each and every material. And don't forget, Barkha, what argument against us which has been raised is that the concerned trial judge or the concerned CBI, they did give a negative report against the grant of remission. But that's not the law. The law doesn't say that it has to be absolute yes or absolute no. It is the cumulative effect of the advisory board, the social workers, and everything. So if they have considered each and every aspect and then they have granted remission, so I don't find any fault in that.
Let me get Zakia to respond to this. Zakia, I think the point that Rishi is making is that this case is not about parole. This case is not about parole. This case is about remission, and remission has been done as per law. And the Supreme Court is should be confining itself to that alone. How do you respond to that, Zakia?
So even if we go by what Rishi is saying, then what is the problem on the part of the government to share this? You know, if this was the process, if this was the line of thinking, and this was the legal argument that they have followed, then they can put it across to the court and for the whole public to know. So, see, I think, there has to be an appreciation on the part of the government that public interest is a very legitimate kind of a concern that citizens of this country have. And it's not like the court has said that today it is Bilkis, tomorrow it can be any woman. So, and we know that violence against women, safety and security of women, sexual assaults on women is becoming a major issue in different parts of our country. What is the norm that we are setting? What is the example that we are setting? All these are much larger questions, and that explanation also is coming from Rishi. It is not coming from the government. So I think this kind of a total refusal to answer questions is something which is going against the very grain of democratic norms and going against the very spirit of our constitutional principles of justice, and particularly about gender justice, because the Prime Minister has been talking about Nari Shakti, and even in the Independence Day
Yeah.
function,
I
it
I
was a
think
huge
I
emphasis. So
I think the
yes, so we have to
operative
walk the talk also, no? The government has to
I
walk the
think
talk.
I think the operative part is that Rishi was among the first to publicly confirm that the center had given its consent to the state government to go through with this remission, and there is no reason then to not place before the court the basis on which this was decided. Abha Singh, rights activist lawyer, is with us. Abha, I'm hoping you can hear us. Please jump in with your response.
Barkha, I've been listening to Rishi. First thing I would like to object is this, that parole is given for 30 days. And here you had these people who were charged with a horrendous offense, which was gang rape with killing 14 people. You are giving them parole at a stretch for 90 days. That is nowhere in the law that parole can be given at a stretch for 90 days. He would know the parole and furlough rules 1959. At least that is what is followed in Maharashtra. That it is maximum 30 days in a year plus 14 days furlough. And here you have 90 days at a stretch. And that is primarily the reason that the government does not want to come in. Second, even the committee which was supposed to look into the remission, it had two BJP MLAs, it had 7-8 people belonging to the party who had alliance to that party. So that means the decision which the Supreme Court is saying again and again, was there an application of mine? Sorry, there was no application of mine. It was particular ideology which everyone was adhering to. So these issues need to be looked into, because also, okay, fine, it was Gujarat which had the powers to decide the remission. They had but what did the law say? It said that the person who had decided the trial, who had given the order, that judge's consent had to be taken. Also, central government was to be consulted. But Gujarat just went ahead and let them go
No,
scot-free.
I'll
Gross
correct you on the
violation of
last.
laws.
I'll correct you on the last point. Rishi has earlier confirmed on this platform that the center did give its consent. The state, under the 1992 law, was mandated to take the center's consent, and that consent was given. But your earlier, so Abha, I want to
We
just
would like
correct
to
you on
see
the
that
last.
consent. No, Barkha, we would like to see that consent.
That
When
is
was it given?
Okay, let Rishi respond to that. I'm just clarifying because Rishi has, with full responsibility, said on this very program that the center's consent was given. Now, Rishi, here, couple of questions there. Parole, yes, you're saying that's not within the ambit of this case, but whether it was lawful, I think that's at the core of the case, whether this remission was lawful, right? And the only way to know that is what formed the basis. There was a suggestion, certainly, that that the CBI special judge, at the time of, not later, but at the time of the conviction, should have been consulted, and he very clearly told me, among other journalists, that he was not consulted. The subsequent CBI special court was consulted. I'm aware of that. So Rishi, do respond to the points that have been raised.
I hope nobody is challenging the grant of parole, and that was never the case in any of the courts. So let's forget and let's leave aside the parole should have been 30 days or 90 days. Yes, the point which is involved in this case is the grant of remission and the process making for grant of remission. Now, I do agree that the concerned CBI trial judge in Mumbai was not taken into consideration. His opinion was not taken into consideration. But don't forget the word. The word used is opinion, and I quote unquote. And therefore, I'm saying that it consists of 10 members, jail advisory board, the concerned DM, the concerned superintendent of police, the concerned superintendent of jail, then 3 to 4 social workers. So mainly because 1 or 2 persons have opined against the grant of remission, that will not make the entire majority of granting remission
But
bad.
the CBI court who convicted these men, the CBI judge is not 1 or 2 people. He's essential, right? You seem
Of
to be
course,
arguing. You seem to be
these are
arguing his
one of
consent.
the.
You seem to be arguing, just correct me if I'm wrong, Rishi, that his consent is not mandatory.
I'm saying his consent is mandatory, but that's not the universe for everything. That in case the judge says yes, okay, tell me one thing. How many cases of remission are there where the concerned trial judge has said yes, he should be released and the government has released? I'm doing a case from Gujarat itself where the concerned trial judge says he should be released because he has covered 15 years, 16 years, yet the government has declined. So the opinion of the concerned trial judge, may it be Mumbai, may it be Gujarat, is not sacrament, that it is the opinion which is binding on the remissionary bodies. So I'm saying it's just one opinion, of course, which has to be considered, not considered, that's a separate issue. But that opinion may be negative, may be positive, it's just an opinion only.
Let me get Abha and Zakia to respond to this. The point is that if this is not placed before the court, right, there's been some suggestion that it can be placed in a sealed cover, though this Supreme Court is not inclined to seal covers. I think they've made that clear. But there's also been a suggestion that maybe this can be placed in a sealed cover. But the point is, why should people at large not know what was the basis, Zakia, for these men to walk out? Zakia, let's bring you in, and then Abha.
So this is a question of accountability. Everybody, the whole country was horrified when these culprits were set free. And everybody has been, asking what was the great wisdom behind granting this remission. So now it's up to the government to come out clean and share what was the reasoning, what was the process, whether it was followed, whether it is legally correct, whether it's morally, ethically correct, that is for the public to decide. But it is this kind of opacity which is very, very troublesome. I think the way they are refusing to now also comply, and the way they are refusing to share the reasons, it appears that somebody up there thought was too drunk on power and thought that probably thought answers will never be sought. They seem to be enjoying that kind of they think they enjoy some kind of impunity. So now when answers are being sought by the victim herself and by some public spirited individuals, it's becoming like they are taken by surprise and they're refusing to comply.
Let me bring up Rishi to respond to that, and also take a question from our Mojo member. Yeah, sorry, let me get Rishi to respond and also take a question from a Mojo member who says, no one, including the Supreme Court, so far knows the basis on which these guys were released. Secondly, they had killed children. I think that's important. Bilkis Bano's daughter was killed. There was a loss of other family members. Not 1 or 2, but all of them were released piecemeal. And I think that's what's been objected to. The remission policy is not meant for wholesale release. Someone could have argued that this person was not directly involved this person was tangentially involved. He was not the one who was the killer. But Rishi, none of that happened. And I think people want to know, the country wants to know, the court wants to know, bhai, what was the basis? Rishi, please respond.
Yeah, I want to respond in two ways.
Yeah.
Firstly, suppose imagine a scenario where out of this 11, 5 would have been released, and 6 for some reasons were not released. So, were the victims would be satisfied that okay, 5 are released, so therefore we are not going to challenge the grant of remission? Of course, no. And imagine the remaining 6, the heartburn which they will have, because don't forget this is a case where what you call in law unlawful assembly was roped in. Nobody was a direct witness that who was actually raped and who was actually killed. So everybody was framed because of unlawful assembly and common object, unlawful object, I may say so. So therefore, everybody was released for the not for the reason that one is getting the benefit, so therefore remaining 10 should also get the benefit. All were released because the Supreme Court in May 22 delivered a judgment which says that Gujarat policy of 92 would be applicable, which also says that policy which I earlier mentioned, that the policy doesn't say 14 years actual, the policy says 14 years with set off. Set off includes parole, remission, whatever you call it. So the policy is upheld by Supreme Court, and this brings to me a very second and very crucial point which I started when I joined this interview, that we would be questioning, at least I would be questioning the maintainability of Bilkis Bano.
On what grounds? On what grounds? On what grounds?
Yeah, I'm coming to that, and that's a very fundamental criminal question, jurisprudence question, which is that don't forget, after the judgment of Supreme Court of May 2022, Bilkis Bano herself filed a review petition, and that review petition got dismissed in December 2022. Now, therefore, yesterday in the court, I had prayed that please supply us the copy of review petition, which was graciously sent to me today by email by Shobha Gupta. And we would be raising this preliminary objection because the Supreme Court has held that in case in fact, before Supreme Court, the review petition grounds which has been raised is identical para by para which has been raised in this present writ petition. So Supreme Court, a constitution bench in Rupa Ashok Hura has held that you cannot challenge an order of Supreme Court by virtue of a writ petition. The only remedy which lies is a review petition, and if review petition is dismissed, the only remedy is a curative petition. So therefore, the filing of Article 32 petition against a Supreme Court order, may it be worse, may it be bad order, is not maintainable per se.
Okay, you're making a lawyer's argument, and I let a lawyer.
No, this is a very fundamental argument.
No, I'm not deriding it. I'm just saying I'm not a lawyer, so a lawyer should respond to this argument. Abha, you should respond to this argument, but it's a technical point. He says it's a fundamental point. He's going to question the maintainability. As far as I know, the 2nd of May has been scheduled by the Supreme Court to be. Rishi, please correct me if I'm wrong. The final day of this hearing, right? Am I right, Rishi?
There is nothing of final day in Supreme Court.
Okay.
Matters can still.
Okay, all right. Fair enough. Fair enough. The other thing we haven't spoken about is that an angry Justice Joseph has said that if you refuse to produce the material, we can hold you in contempt. It was an oral remark, but it was made nevertheless. So we are seeing a very angry argument developing between the center. No, Rishi, you don't agree? I was going to let Abha respond, but you can interject.
You see, I have been practicing the Supreme Court for the last 25 years. Justice Joseph is one of the judges who's never angry. You take it from me on record.
Okay.
But of course, he was perturbed. He was perturbed.
Yes.
That's why I started in the beginning that he was perturbed that when he have brought the files, what's wrong in just
and that is the core of this conversation from a public interest point of view. Why should we not see what's in these files? Maybe there's some compelling reason that we don't know about. Bataiye hame. Abha, please go ahead.
Yeah, absolutely, Barkha. There is a principle in law called right to know. So everybody has the right to know, and plus the victim has a right to know what went into it. So they cannot deny her that information. Secondly, when we talk of the 92 remission, fine, you are going by that. You say yes, because of that rule, Supreme Court had said we've gone ahead. But then you have violated the basic principle, whether there was application of mind, and bigger than this is anything on justice believes justice should not only be delivered, but it should seem to be delivered. So everybody is feeling that justice has not been meted out to Bilkis Bano, and so that you are defeating that very dictum. So let us, and also There are various Supreme Court judgments which say procedure is a handmaid of justice. It should not deny justice. So how can you take technicalities to deny justice to a victim, and that to a victim who was 21 years old, who was pregnant with a child, was gang raped? So I think let us not just go into the technicalities. What the Supreme Court is also trying to see is whether justice was meted out to this young woman who was...
Yeah, I have just a minute left, but before I take Rishi and Zakia's last comments, I want to draw your attention away from Gujarat to actually a very disturbing story from Uttar Pradesh, where men accused of rape have been granted bail, and they come out and they burn the victim's house. The victim, or rather the survivor, was an 11-year-old child. Can we come out of these graphics and actually show the images that I'm actually speaking about? If you can see, the images I'm showing you are from Kanpur and Unnao in UP. Now, what happened here is that there was an 11-year-old child victim of gang rape. And from that rape, she produced a baby of 6 months old. And her parents had another child who's 2 months old. And those two babies that you see on your screen are now battling burn injuries. Why? Because the men who have been accused of gang rape wanted this family to withdraw the charge, right? And they refused, and they came and they burnt their home. They burnt their home, and in that fire, these two babies, one 6 months old, one 2 months old, have suffered serious burns, and they're being treated in a Kanpur hospital. Now, why do I mention this? I mention this because what has happened, Rishi, with respect, in the Bilkis Bano case creates impunity. And it says to men like those who have been charged in Uttar Pradesh, let's bring up Rishi. It says to them that you can do this and you can get away from it. And the condition of the babies is so serious that they've now been moved from Kanpur. I've just got an update to Lucknow because these infants are battling grave burn injuries. And I am being so disturbed by what has happened because I keep thinking of these two babies and this 11-year-old girl who was raped. And I think, Rishi, the point is that what we see happen in Bilkis Bano case, a lot of people would say, emboldens those men, those accused who went and burnt a victim's house. So, Rishi, I want your last remarks.
You see, again, as Justice Joseph said, you're mixing oranges with apple. This is a case where the man is under trial. Of course, they would be convicted on the evidence. And here's our case where they have been convicted. They have served out the entire sentence. And now after this, they have been granted remission. So therefore, of course, nobody is running away from the fact that, yes, Bilkis Bano case was one of the grotesque case which I have also come across in my life. But for that, they have already served out the sentence as per the policy. So what more you require for them to? They certainly nobody has, no court has given them death sentence.
But you know, Rishi, if you had told us maybe one of them, or two of them, maybe they have served 14 years, let them walk out. Maybe there would have been certain acceptance, but wholesale remission.
Barkha, you take it from me. Even a single person who would have been out, they would have.
The debate right now, Rishi, is: do you personally believe that the centre and the Gujarat government should place these documents before the court? Yes or no?
Yes, certainly they should have, and they ought to have.
Thank you for saying that. We will leave it there. Zakia, do you want to add a thought? I have to close. A quick thought.
So
Zakia?
History will not forgive this mockery of justice. Bilkis has already suffered a lot. We need to do right by her now, and the government must give the answers and must roll back the decision. I think this is what the women of India want, and even the men of India want. So this should be undone. This mockery should be undone.
Let's wait to see what the court does. It's going to be a very intriguing moment in law and public affairs if the centre and the state refuse to actually place these papers, which even the counsel for the convicts says should be placed before the court, because why take a decision that you need to be defensive about later? Just tell us why you've taken this decision. We leave it there. It's a very disturbing story. The news coming in from UP is also very disturbing. Leaving it there. Thank you, Zakia, Abha, and Rishi. And to our audience, thank you for watching. Take care. It's great to see you here. Thank you for watching our work. If you haven't subscribed yet, don't forget to click the bell icon and subscribe to Mojo Story and support independent, robust journalism.